Hello everyone, welcome to our new EUCROSS webinar series. I'm Alexandra Nemoylen from the Leuven Centre for Global Governance Studies at KU Leuven, and I will be moderating this webinar on the role of national parliaments in the conclusion of mixed trade agreements with Dr. Guillaume van der Loo and Dr. David Kleimann, who are both part of the EUCROSS network and are joining us live today. Guillaume is postdoctoral researcher and senior member of the Leuven Centre for Global Governance Studies, where he takes part in the interdisciplinary research programme Connectivity. His research focuses on EU external relations, law and policy, in particular the EU neighbourhood relations, EU external competencies, EU international agreements and trade policy. He has published widely on these topics in international peer-reviewed journals, such as the Common Market Law Review, Legal Issues of Economic Integration, and the European Law Journal. He has also published a monograph on the new generation of EU association agreements and deep and comprehensive free trade areas concluded with ENP countries, as well as an edited volume together with Professor Michael Hahn on the law and practice of the Common Commercial Trade Policy the first 10 years after the Treaty of Lisbon. Guillaume is also a researcher at the CEPS think tank in Brussels. David is a visiting lecturer at the Law Faculty of the University of Mannheim, and he conducts postdoctoral research on the strategic potential of EU external economic policy for the Global Governance Programme of the European University Institute. He holds a PhD in European International and Comparative Law from the European University Institute in Florence. Previously, he has served as an advisor to the chairman of the European Parliament's Committee for International Trade, and moreover, he has acted as a consultant to the European Commission project EU Trade, as well as the World Bank's International Trade Department. In 2009, he coordinated the trade policy project of the German Marshall Fund of the United States Brussels office. We're glad to welcome you both to the EUCROSS webinar series. Now, before we start, I will say a few words about EUCROSS. This is a Jean Monnet network co-funded by the Erasmus Plus program of the European Union, entitled The European Union at a Crossroads of Global Order. It investigates the challenges and opportunity that the European Union and its main international partners face as our conventional understanding of global order is put into question and multilateralism is contested. It has two main areas of focus. On the one hand, the EU's strategic reorientation in global affairs and its enduring support for a rule-based cooperative international order, and on the other hand, the specific challenges and opportunities for bilateral and multilateral cooperation with its main international partners, including the United States and the BRICS countries. Among the various policy areas under study in the EUCROSS network, today our speakers will be focusing on trade, topic that is, of course, extremely timely, also considering how contentious this area of policy has become in recent years. And in some ways, the latest European elections have also shown how the clash between those who support the role of the EU, for instance, in areas such as trade, and those who instead prefer to see many such competencies brought back to the member states. So in this webinar, our speakers will aim at bringing some clarity in the complex interplay of competencies between the EU and its member states. As for the general structure of this webinar, first of all, Guillaume will present for about 25 minutes, and David will share with us his reflections. And Guillaume will have the opportunity to reply. During the presentations, you may send your questions to me via the webinar chat box, which you can access from the control panel. After the presentations, I will bring your thoughts and questions into the discussion and allow Guillaume and David to respond. It's my pleasure now to give the floor to Guillaume, and I very much look forward to his presentation. You have the floor, Guillaume.
Many thanks, Alex, for this very kind invitation, and good afternoon to everybody. So indeed, as already mentioned, the subject of concern today is the role of national parliaments in the conclusion of mixed trade agreements. Now, as you may know, and we will come back to that later on, mixed agreements or mixed trade agreements are agreements that are concluded by the EU and the member states on the one hand, and a third country or an international organization on the other hand. And this implies that all the member states of the European Union are also required to ratify the mixed agreement. Now, as such, mixed agreements are not really new. You can see here the picture in black and white, which is actually the first mixed agreement concluded by the European Union, which was the association agreement with Greece in '61. And since then, the European Union has concluded numerous mixed agreements with countries all over the world, association agreements, trade agreements, and so on and so forth. And until now, actually, the role of the national parliaments in the member states during the ratification of these agreements was not really problematic. Often it was considered that national parliaments, after that their respective governments signed the agreements, just rubber stamped the agreement and that it was then ratified. But over, the last 5, 6, 7 years, we had some very interesting developments which had a big impact on this. First of all, we have, of course, a couple of years ago in 2016, we had the issue of the region of Wallonia and Belgium that jeopardized for a couple of weeks the signature of the EU-Canada CETA. And this then, of course, triggered a heated debate on the balance between the effectiveness and the legitimacy of the EU's trade policy. Is it really required that all 28 member states vote in the conclusion of trade agreements, or should only the EU conclude these trade agreements to have a more efficient trade policy that actually can deliver much faster? And then, of course, this fitted in the broader context of the heated debate about the impact of TTIP and CETA, that suddenly a lot of member states and parliaments were, or in any case, members of national parliaments as well, were increasingly interested in EU's trade policies and in EU trade agreements. And another issue that I will use a couple of times as an example is this very strange referendum in the Netherlands on the EU-Ukrainian association agreements, where a national referendum actually jeopardized for a while the ratification of an association agreement that the EU had concluded with Ukraine. Now, before we can really delve into the impact or the role of national parliaments, I think it's very important to briefly repeat again why we have mixed agreements. We have political reasons for that, but also legal reasons. Then we will briefly give an overview of the practice of mixed trade agreements after the Treaty of Lisbon, because as you know, there are a lot of trade agreements on the EU agenda, just signed or still under ratification. So let's see what the EU is cooking up in that regard. And then briefly, we will give some comments on the parliamentary involvement in mixed agreements, focusing on national parliaments. And then we will try to identify or to answer some questions. For example, is there really a duty for national parliaments to ratify this? And what happens if a parliament doesn't ratify an agreement? And what elements of a trade agreement do national parliaments need to ratify? And what is their role and the role of the provision application of trade agreements? Let's see how far we will get in the first part of this session. Maybe we don't get into the last 2 points, but then we can pick this up during the discussion. I also want to flag that this is a legal analysis, so it's not an overview of the practice of what actually national parliaments are doing vis-a-vis specific agreements. It mainly, or I will mainly try to give the broad legal framework of this, and then maybe we can dig a bit deeper during the discussion. So why mixity? This is a rather complex issue, so I will avoid the legal nitty-gritty in the case law of the Court of Justice. But in any case, it's important to stress that there are legal reasons why agreements are mixed and political reasons. Now, the legal reason is you can actually have 3 types of mixity. First, a trade agreement needs to be mixed. So mixity is mandatory when a trade agreement or an international agreement includes provisions which fall under the competences, the exclusive competences of the member states. So most trade agreements cover 90% actually at this point exclusive trade competences. So competences for which the European Union is exclusively competent. However, if an agreement, a trade agreement or any other type of agreements, includes also provisions which still fall under the competences of the member states, actually this makes the entire agreement mixed. Now, you have an EU-only agreement, so a non-mixed agreement, if actually all the provisions of an agreement fall under the exclusive competences of the European Union. For example, trade, common commercial policy, is an a priori exclusive competence of the European Union. If you look at the treaties, Article 3, you can find a list of areas which fall under the exclusive competence of the European Union, and trade, common commercial policy is one of them. Of course, today trade agreements includes also provisions which are not pure trade as such, but are trade related. And there it could also be that these, nevertheless, that these provisions are viewed as an exclusive competence of the European Union through the ERTA doctrine. This is now codified in the Treaty of Lisbon, but basically this means that the European Union is also exclusively competent to conclude an agreement insofar that the agreement may affect common rules or alter the scope. And this is how it is codified in the Treaty of Lisbon. What does this mean? If the European Union concludes a trade agreement and this trade agreement overlaps with an area in which the European Union already has adopted legislation, actually this ERTA doctrine kicks in, and the European Union is exclusively competent to conclude that agreement. So you have mandatory mixed agreements. An agreement is mixed or has to be mixed when it concludes or includes provisions falling on member state competences. An agreement is an EU-only agreement, so it is not mixed if it only includes provisions falling under exclusive competence of the European Union. And then you have a specific case, which I want to mention at this point, is facultative mixity. The European Union also has shares some competences with the member states. Now, if you have an international agreement which considers which includes competent provisions falling under exclusive competences and shared competences, recent developments and case law of the Court of Justice have confirmed that actually the Council, so the legislator, but in this case for trade agreements, so the Council can decide whether or not to have the agreement mixed or not. But again, I don't want to focus too much on this issue now, but these are the legal reasons why you have mixed agreements. So actually, basically, if you conclude, or the EU wants to conclude an international agreement, and actually the agreement or the envisaged agreement includes provisions for which the European Union is actually not completely competent, but actually it still falls under the competence of the member states, you also need to bring in the member states on board and the signature and the ratification of the agreement. Of course, there are also political reasons for mixity, because in the end, as you will explain further on, this implies mixity, that all the member states need to ratify the agreement. So actually this gives the member states a lot of power, or in any case, a kind of a veto power, because of course they can not ratify the agreements, and this would then bring the agreements into jeopardy. So mixed agreements give more visibility on the international stage to member states, and also a veto power, even in the area of trade where actually qualified majority voting applies. So if you have a trade agreement where normally qualified majority applies, and it is mixed, actually this mixity nullifies the qualified majority voting in the Council. Also, the option of mixed agreements is considered because sometimes it's just an easy solution. Instead of going into a very difficult technical debate if the EU wants to conclude an agreement, which is very broad and comprehensive, and if the EU and the member states to identify which provisions could or may be falling under the competences of the member states of the European Union, actually, if you conclude a mixed agreements, you can actually bring this all together and you can avoid very technical legal discussions. And it is also considered that sometimes member states deliberately include provisions that exclusively fall under their competences to make an agreement mixed. So this is what I refer to with a deliberate mixity. Now, if you look at the Treaty of Lisbon, or actually what happened since the Treaty of Lisbon, we see that we have sort or less 40 mixed agreements after the Treaty of Lisbon. Just like before the Treaty of Lisbon, all the very broad and comprehensive framework agreements, which are association agreements, broad partnership and cooperation agreements, are mixed. However, paradoxically, the European Union or the Treaty of Lisbon broadened the scope of the common commercial policy in the area of trade. More than ever, elements or the common commercial policy is broadened by the Treaty of Lisbon. So this means that actually, the logic would be that less trade agreements should need to be mixed, because actually the scope of the exclusive competence of the European Union and the area of trade has been broadened. However, if you look at the practice, most of the trade agreements since the Treaty of Lisbon have been concluded as mixed agreements. Now, in addition to the legal and the political reasons, there is one very important element which we need to mention, and that is Opinion 215 of the Court of Justice on the Singapore trade agreements. So over the years, there was always a competence battle between mainly the Commission on the one hand and the Council and the Member States on the other hand on the scope of the common commercial policy. Of course, the Commission always wanted to have a very broad reading of the common commercial policy, which also implies that trade EU-only agreements, where not surprisingly, the Council and Member States always argued for a very narrow interpretation of the exclusive scope of the common commercial policy to trigger mixity for trade agreements, so that they have this veto in the ratification procedure. Now, the Court of Justice had to the previous Commission asked, or actually it was already previous Trade Commissioner Karel Hucht, asked an opinion procedure to the Court of Justice with regard to the EU-Singapore Free Trade Agreement. And the question basically was, please, Court of Justice, tell us once and for all which provisions of this EU-Singapore Trade Agreement fall under EU competences, exclusive competences, and which provisions not. Now, I will not go into the specifics of this case, but the court basically said that almost everything in the EU-Singapore trade agreements, which is kind of one of these new examples of the new generation of e-trade agreements, falls under the exclusive competence of the common commercial policy. It had a very broad reading of the common commercial policy. The court argued that a measure falls under the common commercial policy if it relates specifically to such trade, and that is essentially intended to promote, facilitate, or govern trade, and has direct and immediate effect on it. So this is a bit of a vague, but nevertheless broad criterion. And in the light of this, the court argued that, for example, in the Singapore FTA, everything that relates to trading routes, technical barriers to trade, sanitary, phytosanitary measures, but also even issues such as sustainable development, public procurement, intellectual property rights, services, and foreign direct investment fall under the exclusive competences of the European Union. There are only two notable exceptions, which is portfolio investments, so non-direct investments, and ISDS, because this Singapore FTA at that time still didn't have the investment court system, but the court ruled that basically everything falls under the exclusive competences of the European Union, with a notable exception of two issues related to investment, portfolio investments, and ISDS, so dispute settlement for investment disputes. Now, in the end, the Commission obviously was rather happy with this result, because 95% was considered by the Court of Justice as an exclusive competence. And then a debate emerged whether or not it would not be an option to split this new generation of trade agreements, to have an EU-only trade agreement covering everything that falls under the exclusive competences of the European Union. That, of course, then is not mixed and only needs to be ratified by the European Union, which is the Council and the Parliament, but not, of course, by all the 28 member states. So 95% we keep in an exclusive EU trade agreement. And then these two issues related to some other issues related to investment, we have a separate investment or an investment protection agreement. And then this would be a mixed agreement, because it still falls under the not under the exclusive competences of the European Union. And indeed, in 2017, the Commission made such a proposal when after the context of the State of the Union of previous Commissioner, President of the Commission, Juncker, where the Commission actually proposed also to conclude a new trade agreement with Australia and New Zealand, and it referred very much to the opinion of 215 of the Court of Justice, and actually it's already suggested that maybe we would need to have these from now on these EU-only trade agreements, and we can have these issues that fall under the not only exclusive competence of the European Union in a separate agreement. But the Commission immediately already added that national parliaments the Commission, of course, didn't want to be perceived as shielding away national parliaments in this process. No, the Commission suggests that national parliaments should nevertheless play a role in trade policy by scrutinizing their respective governments at the level of the Council, at the level of the European Union. And therefore, the Commission, for example, from now on also communicates its, and in light of also the transparency exercise that is going on, the Commission sends draft negotiation directives already immediately to national parliaments to involve them. So on the one hand, the Commission was saying, let's have EU-only agreements, but on the other hand, the Commission was also very aware that national parliaments still need to play an important role. And the European Parliament actually had a bit of the same position, also in the light of these new agreements that are currently being negotiated with Australia and New Zealand. The Parliament actually also, in some resolutions, argued that from now on the European Union should split trade agreements. On the one hand, exclusive trade agreements, and on the other hand, these mixed investment agreements. And actually followed to a large extent. In a document in May last year, the Council noted the Commission's position in that regard, with regard to the splitting of trade and trade and investment agreements. But the Council actually wants to stress that nevertheless, it's still up to the Council to decide on this, and it will decide on a case-by-case basis. And it stressed that association agreements, which are, I mean, from a political point of view, the most ambitious agreements that the European Union concludes, and which very often also have a trade component, that association agreements, in any case, will remain mixed. For example, the one with Mexico, Mercosur, Chile. And this is, of course, rather important because many of the agreements currently on the EU agenda are part, or trade agreements are part of an association agreement. But we'll come back on that later on. So, indeed, if you look at the practice of trade agreements of the last 2-3 years, of course, CETA, which triggered this debate. So the EU-Canada CETA agreement was still signed and concluded as a mixed agreement, but it is provisionally applied since September 2017. But then the EU-Japan trade agreement was actually the first trade agreement was concluded as an EU-only agreement, also last year. But the EU-Japan trade agreement is not flanked by an investment or an investment protection agreement, mainly because Japan is not really a big fan of the EU's investment court system. So actually there is no flanking mixed investment agreement but concluded or signed with Japan. However, now we have 2 examples of such split trade agreements with Singapore and Vietnam. These agreements were negotiated originally as one agreement. The European Union, and of course together with both Singapore and Vietnam, decided to split the agreements and to have an EU-only trade agreement and to flank this with an investment protection agreement, which is mixed. Now, if you look to some other agreements which are on the EU agenda, you can see them here in this box. It indicates that in any case, the Council, this is illustrated by the Singapore and Vietnam case, the Council is very much open to splitting these trade agreements. However, as already mentioned, it's stressed that association agreements will still be concluded as mixed agreements. And if you look at very important agreements, the Mercosur agreement, just recently negotiated, as well the agreement with Mexico, which is also just negotiated, and the negotiations that are currently going on with Chile. These 2 agreements are both part, or will be part of broader association agreements. So nevertheless, these agreements will still be mixed. Also, for example, with Tunisia and Morocco, there are negotiations ongoing in the framework of an association agreement, so all these agreements will also be mixed. So it is not that we suddenly have a complete move towards only EU agreements. Mixed agreements are here to stay. It will depend on a case-by-case basis whether or not we will have a split agreement or not. But basically, in the future, if you have a standalone trade agreement, so only a trade agreement, most likely you will end up in the split trade agreement and investment agreement, but when it's part of a broader association agreement, it is still here. Or we will still have a mixed agreement. Now, a few words about the parliamentary involvement in mixed agreements. So as I already mentioned, mixed agreements are concluded by the EU and the member states on the one hand, and a third country or third countries on the other hand. So this means actually that both the European Union and the member states are contracting party to a mixed agreement, although the preamble groups them together. And if you look at the provisions and trade agreements which define the parties, you see that indeed the parties are the Union and the Member States, or the Union or the Member States, and their respective competences. So this implies that indeed both the European Union and the Member States need to sign and ratify the agreement, because all the entry into force clauses of the recent trade agreements or trade agreements as such state that the agreement can only enter into force if all the parties have ratified the agreements according to their own constitutional procedures. So all the parties, this of course refers to, on the one hand, the European Union, which then is the Council and Parliament, and the 28 member states on the other hand, and the third country. Now, this is mainly the case for bilateral trade agreements. The case for multilateral agreements is a bit different because the entry into force clauses are a bit different. So actually, in the rest of my presentation, I will only focus on bilateral trade agreements, which actually is still the biggest chunk of EU trade agreements. Now, of course, Parliament is involved, or there's a parliamentary oversight on EU at the level of the European Union and at the level of the Member States. At the level of the European Union, of course, we have the European Parliament, which has to give its consent and which is also very much involved or has a voice during the negotiations of the agreement. In any case, it is informed and consulted during the negotiations. And at the EU level, actually also national parliaments are involved, because national parliaments can scrutinize what their respective governments are cooking up in the Council or in the Trade Policy Committee. But of course, with regard to mixed agreements, member states are also directly involved because they need to ratify the agreement in the end when the agreement is a mixed agreement. So how many parliaments do actually need to ratify mixed agreements in the European Union? You very often hear or see the number 38 national parliaments in total in the European Union need to ratify a mixed agreement. And actually, you can't really put a number on it because most constitutions in member states don't say that any type of international agreement needs to be ratified by the national parliament, but they define, for example, that the most important trade and economic cooperation agreements or trade agreements need to be ratified by the national parliament, or international agreements that have implications on the budget or that change borders. I mean, all these fundamental international agreements require the ratification of the national parliament. Now, I will not, there's no time to give an overview of all the procedures in the 28 member states, but basically you can say in all the member states which have a unicameral parliament, so only one chamber, that one chamber always need to ratify trade agreements, EU trade agreements. A notable exception is Malta, where the conditions for involvement of the national parliament are actually very strict. And then in all the other member states which have a bicameral parliament, so two chambers, actually in most states, both chambers need to be involved and need to ratify the agreement. We have some exceptions, such as in Belgium and Ireland and Slovenia, where it's only the lower house which need to ratify the agreements. And in Germany and in Austria, it depends, the involvement of the upper chamber depends on the relevance of the envisaged agreements for the regions. Also a specific case is the UK, where actually the Parliament in the UK, the House of Commons and the House of Lords, cannot formally reject an agreement. However, the House of Commons can indefinitely delay the ratification and keep postponing this, whereas the House of Lords can only do this once. And of course, this is not unimportant, considering that maybe in a distant future, we have a trade agreement between the European Union and the UK, which most likely will be mixed. And of course, a special case finally is Belgium, where in addition to the federal parliament, also the different parliaments of the regions, of the communities and the regions will need to be involved. And of course, this now explains why the region of Walloon has the ability or the option to jeopardize the signature of CETA 2 years ago. Now, very briefly, let me just see how much time I have. Let's try to identify a few of these legal questions and dilemmas that I mentioned before. The most important one is there a duty for national parliaments to ratify these mixed agreements? Now, so far, and it's important to note, there are no examples of national parliaments or member states that have really rejected a mixed agreement. There are some examples where it took a long time for some member states to ratify an agreement, or that the member states tried during the very final stages of the negotiations, tried to jeopardize the signature, for example, in the case of Wallonia to extract maybe some last-minute concessions. But in the end, all the mixed agreements so far were bilateral mixed agreements ratified by the member states and their national parliaments. Nevertheless, considering the climate of today, the result would be if one member state does not ratify an international mixed agreement, the agreement cannot enter into force. As already mentioned, if you look at these entry into force clauses, they clearly state that the agreement can only enter into force if all the contracting parties, hence for mixed agreements, also the member states, ratify the agreement. Now, does this mean, is there, according to EU law or international law, a kind of an obligation for member states to ratify an agreement? Because of course, most of the trade agreements or trade agreements today include 95% or 99% only EU competences, even when they are mixed. Only a few provisions following the competence of the member states. So if a member state would actually refuse to ratify an agreement for whatever reason, this blocks not only those provisions falling under the member states' competences, no, the states would de facto block the entry into force of the entire trade agreement, including the provisions falling under the exclusive competence of the European Union. So basically, you would have really a strong or a very important constitutional problem, because by doing so, the member state would actually preclude the European Union from exercising its exclusive competences in the area of trade. And of course, I mean, without going into really basic principles according to EU law, but of course, this is really a no-go, because this creates problems with regard to the allocation of external competences and the nature of exclusive competences of the European Union in the area of trade. Now, does this mean that there is a kind of an obligation on a member state to ratify it? An important principle in this regard is, of course, the duty of cooperation, which is one of the key constitutional principles in the treaties, that the member states, together with the European Union, should help each other in implementing the obligations of the treaties. And there is a lot of case law of the Court of Justice on the duty of sincere cooperation, even in relation to mixed agreements, where the court stated that this means that the member states and the European Union should ensure close cooperation in the process of negotiation and conclusion of international agreements, and that this stems from the requirement of unity in an international representation of the European Union. Now, without going into the legal nitty-gritty, this means that the duty of sincere cooperation is important. However, of course, you cannot stretch this constitutional principle that far that this would mean that you can oblige members of parliament or national parliaments to ratify an agreement. Because of course, I mean, member states actually still have the sovereign right to ratify or not ratify the provision that fall under their competences. According to international law, I mean, you can even involve that the consent to be bound by an agreement can only be expressed voluntarily. And of course, in practice, this legal principle in the treaties cannot really dictate the voting behavior of members of parliament in national parliament. So also important to note, actually, there are some cases recently where a member state did not ratify mixed agreements, not really in relation to trade agreements, but for example, in relation to aviation agreements. For example, here, as you can see, an aviation agreement with Greece or the EU-Morocco agreement. And there are some cases where member states really did not ratify, for whatever reason, that agreement. And actually, the Commission started against these member states infringement procedures. And in the recent opinions, which introduce, of course, the infringement procedures, the Commission relied very much on the duty of cooperation. For example, here we have a quote of such a procedure where the Commission underlined the obligation of the member states to facilitate the achievement of the Union tasks and to refrain from any measure that could jeopardize the attainment of the Union's objectives. But of course, these infringement procedures related to the non-ratification, or in any case, the absence of a ratification procedure. It is not that the Commission was challenging a negative outcome, because of course that would be a bridge too far, but the Commission really tried to use these infringement procedures in any case to get the process going and to initiate a ratification process at member state level. So with regard to the duty of cooperation, or in any case, the conclusion is that there is a kind of a duty of a member state, and this is my personal conclusion, now combining all of this, that there is a duty on a member state to initiate the national ratification procedure in a reasonable time, but of course that there is no obligation with regard to the outcome of that specific procedure. But nevertheless, this constitutional deadlock remains if you have a national parliament that chooses to exercise its right not to ratify a bilateral agreement. By the same token, it de facto blocks the union from exercising its exclusive competences because the entire agreement, cannot enter into force. Now, there are some solutions that have been proposed that you should have incomplete mixed agreements, that you should only have enter into force the provisions falling under EU competences. But of course, this is very technical, and then you end up with the provisions or with the problems why, in any case, in first place, you have mixed agreements. So that is not really a solution. Now, I still wanted to cover two more issues. I will only mention one issue. The second one I will just briefly mention is what do national parliaments need to ratify? Actually, from a very strict legal point of view, national parliaments can only have to ratify the provisions of an agreement falling under member state competences. But of course, in practice, this does not happen. Members of parliament, of national parliaments, of course, look at the entire agreement, and then they make up their mind whether or not, members of parliaments are not going to the legal nitty-gritty and check which provisions under the competences of the member states or the European Union. So there are some problems with that, but there are also some solutions. Now, a bit more controversial, and that's the last thing that I want to mention, is the role of national parliaments with regard to provisional application. Now, provisional application of mixed agreements is sometimes considered as undemocratic. Now, very briefly, provisional application, if you have a mixed agreement, normally the ratification of a mixed agreement in the European Union normally takes 4 to 5 years. But the classic way to circumvent this long ratification procedure is provisional application. This means that the European Union and the contracting party will provisionally apply already those parts of an agreement that fall under union competences. I mean, strictly legally speaking, the member states can also provisionally apply an agreement, but of course that's the entire point of provisional application, that you don't have to wait for member states. So provisional application in the EU context basically means you and the third country are applying some or most of the provisions of the agreement falling under union competences. And the procedure for that is foreseen in the treaties. So the Commission needs to make a proposal, or in some cases the Commission and the High Representative, and then the Council needs to approve this. From a strict legal point of view, the European Parliament is not involved, but a practice has been developed that actually for trade agreements, the Council or the European Union will only start with the provisional application after hearing the consent of the European Parliament. Now, member states and national parliaments are not involved in the provisional application of the European Union. Of course, member states indirectly are represented by the Council, but member states as separate entities have no role to play in the provisional application. And this was sometimes considered as undemocratic by national parliaments. For example, when we had this referendum in the Netherlands on the Ukrainian association agreements, the provisional application of the agreement actually already started before there was a referendum. So therefore, some members of the national parliament in the Netherlands found this a bit strange that there was still the referendum, but nevertheless, even before the referendum, actually 90% of the agreement was already provisionally applied. Also, in the context of CETA, some members of parliament were found it a bit strange that actually already, for example, at this point, 90 or 95% of the EU-Canada CETA trade agreement is
Guillaume, can I ask you to bring it to a close so we can move on to our discussant?
Okay, perfect. Basically, to sum this up, with regard to the provisional application, the outcome is that after in the context of the problems that emerged with CETA, some statements were adopted that if a member state, or for example a national parliament, would decide to ratify an agreement, the ratification fails, and also the provisional application needs to be terminated according to EU procedures. However, what the EU procedure is, maybe we can pick this up during the discussion, but I will leave it with there. But yeah, I will leave it there. And if there are still nevertheless some questions or comments with regard to the role of national parliaments with provisional application of mixed agreements, that is that. And if just briefly to conclude, the role of national parliaments, we have this very important development of splitting of trade and investment agreements. So this means actually that you kind of have a shift from direct to indirect parliamentary oversight at national level, because less and less parliaments, national parliaments, need to ratify agreement, but nevertheless, you see that also the Commission and the Parliament has the idea to engage more with the national parliaments at the EU level, at the level of the Council. But mixed trade agreements will not disappear, as for example we have seen in the context of association agreements. And of course, member states more than ever are interested in trade and in trade policy after everything that happened in the context of CETA, TTIP, and even now in the context of Trump trade policies. So thank you for your attention, and I'm looking forward to the comments of David and your questions.
Excellent, Guillaume. Thank you. Thank you very much for this very, I think, already very informative overview that really gives us a sense of the complex balancing act between these two levels of competence and the influence of national parliaments in that context. I would now like to ask Dr. David Kleimann to join us so that he can share with us his reflections on this.
Well, thanks a lot, Alex, and thanks a lot, Guillaume, first of all, for having me in the first place, and especially Guillaume for this really comprehensive and meticulous presentation, which obviously makes it very, very difficult for me now to add anything to the substance that you provided us with which I thought was absolutely splendid. And I have now a rather difficult task. So how do I get out of this? I would try to look at the same phenomenon that you've just presented with a slightly different perspective. And so the objective of mine would be to make an attempt in 10 minutes, which is a rather short amount of time, to explain this entirely new phenomenon in EU external economic governance, which you just discussed, namely the change of practice from mixed to EU-only modus of signing and concluding comprehensive and EU free trade and investment liberalization agreements, which I think, like in the big grander perspective, in the historical perspective, really makes for a transformative moment in EU external economic governance. And my somewhat humble hypothesis in this regard is that this seminal change in common commercial policy or EU external economic governance, such as the split of EU FTAs and investment agreements, can only be evaluated against the background of the three Leuven Council objectives of 2001, which gave a roadmap for the content of the constitutional reform of the European Community and the European Union. And these three objectives, just to remind us, notably are to enhance the legitimacy of EU governments and EU external governments, for that matter, through more democracy, more transparency, and more efficiency. Now, I believe, or my hypothesis, at least, also in papers that have been written on this subject, is that this change, in practice that we've seen can be explained by a reference to the evolution of a new equilibrium of legal, political, and institutional parameters in EU external economic governance. And that the Leuven objectives, that the before mentioned Leuven objectives relating to legitimacy, can only materialize in this new equilibrium as a result of constitutional reform, as a result of litigation, political demand, and institutional adaptation. So just to revisit briefly, what is the phenomenon that we're looking at? Obviously, as you have just emphasized, Guillaume, we're talking about the EU-only governance in common commercial policy and the split. We're talking about the EU-Japan agreement in terms of data points and phenomena. We're talking about the EU-Singapore FTA and IPA. We're talking about the EU-Vietnam FTA and investment protection agreements. as well as the mandates for the New Zealand FTA and the Australia FTA, which have all been, except for the EU-Vietnam FTA and IPA, have been sort of summarized in the Council conclusions of May 8th of 2018 on the Bulgarian presidency on the new treaty architecture, in which the Council acquiesces to the signing and conclusion of EU-only agreements for the first time in the history of the European Union and the European communities. So, again, to briefly revisit what the effects of this new practice is. We have obviously a vast reduction of veto points at the stage of economic treaty signing and ratification and conclusion, from from the unanimity requirement of 28 at the signing stage to 38 legislatures, or up to 40 legislators at the stage of parliamentary ratification. We have a further concentration of interest aggregation at the triangular institutional level in Brussels. We have a change of sources of democratic legitimacy in terms of a vertical subordination of member states' parliaments to the EU institutions, and a vast elevation of the role of the European Parliament as let's say institutional competitors of national member states' parliaments are pushed into subordination to EU governance. And last but not least, we have a reduction of, if you're looking at this from an political economy point of view, a vast reduction of political transaction costs for external economic governance, and reduction of member states' rent-seeking opportunities through vetocracy in regard of trade negotiations. So after decades of this interinstitutional battles over the exercise of exclusive external competence, in litigation and political battles, how have we arrived at this seminal juncture? And my view on this is that there's a coincidence of a number of factors that generate the before mentioned new legal political equilibrium, which is characterized by enhanced de jure legitimacy of the new practice, enhanced input legitimacy in terms of democratic representation, and enhanced output legitimacy of EU external economic governance. So two factors relating to de jure legitimacy that also have been mentioned before. As I said, the only thing I can do right now is to frame the before mentioned presentation in a different way, or the phenomenon in a different way. But what we have is the treaty reform of horizontal and vertical competences through the Treaty of Lisbon, extending or consolidating the vertical competences, the exclusive competences in the area of CCP, and extending the competence, the institutional competence responsibility of the European Parliament in regard of trade. We have, secondly, with regard to de jure legitimacy, the litigation that clarifies the scope and delineates the scope of CCP post-Lisbon. And here we have a number of cases, not only Opinion 215, but also the Conditional Access Convention case and the Daiichi Sankyo case with regard to services. Then we have two important factors, I believe, that relate to output legitimacy and the effectiveness and credibility of external economic governance. And the first one, there's a bit of a paradox here, and the first one being a domestic and international political economy that creates a strong demand for the success of what was originally the Global Europe agenda. And the stakes in the Global Europe agenda of 2006, which have seen also recent updates in other Commission communications. The stakes in the global Europe agenda have considerably increased since 2016 through external threats to the Union system of governance and values, through the Trump administration, through Brexit, through and in addition to that, through through economic competition embodied by Chinese state capitalism. So there's, a sort of enhanced member state unity for effectiveness of governance and, to create more output legitimacy of common commercial policy. To generate further competitive liberalization pressures onto the US and the British economy, and thereby indirectly to militate against anachronistic political developments in those countries. Secondly, having in mind sort of the stakes, the arguable stakes that the EU has in the success of the global Europe agenda, there's a persistent threat to the success of that agenda embodied by the vetocracy that has been sort of practiced by member states early on in the Lisbon era in regard of the EU-Korea FTA. We had the Italian veto threat to the EU-Korea FTA triggered by heavy lobbying by the car industry, especially by Fiat. And then we had the more recent, which will remain in our memory as the Wallonian CETA drama, the threat of Belgium not to sign and not to ratify CETA if certain conditions are not met. So these two factors have increased increasing demand or have created an increasing demand for enhanced institutional effectiveness or output legitimacy. And third, we have factors relating to input legitimacy and democratic governance. And I would name two things here. And first of all, a high capacity democratic control, high capacity democratic control through the European Parliament. If compared to 10 years ago, we've seen a rather fortunate development with regard to the European Parliament in terms of sort of rehearsed inter-institutional practice and sort of conventions that have enabled the European Parliament to be an effective player in this triangular institutional relationship. And secondly, we have seen also enhanced use of member states' parliamentary potential through increasing engagement at the member state level through channels codified by national constitutions. Guillaume didn't have the time to go into detail of the practice of member states' parliaments with regard to democratic control of mixed agreements or EU-only agreements. I'm not going to have that time either, but we can say that before Lisbon, we had a practice of national parliaments where it was basically a rubber stamping of trade agreements that were presented to them much after, long after the negotiation of these agreements, whereas now national parliaments are much more engaged, also because of the political stakes that are involved with regard to the change from WTO negotiations to important bilateral agreements. So this has created the conditions for an enhanced representation both at the EU and the member states level. So looking at factors relating to input legitimacy, de jure legitimacy, and an output legitimacy or effectiveness of EU external economic governance, we can conclude that the new treaty design and treaty making practice does create this new legal and political equilibrium, which enhances the legitimacy of EU external economic governance, of course, to some extent, the exceptions do somehow also confirm the rule. We have the exception of association agreements that Guillaume has already referred to. At the same time, we also have a development here that there are, let's say, consistent rumors that within the Commission that even association agreements could be split into a political cooperation part or a framework agreement part that would be subject to mixed agreement, ratification, signature and ratification, and a trade part that could be subject to an EU-only signature and ratification. So, for instance, Barnier has been
David, sorry to interrupt you. Would you mind if we? Okay, then go ahead. Then we can move on to the Q&A.
For instance, Barnier has recently toyed with the idea of sort of splitting the future relationship agreement between the European Union and the UK into a part that would be subject to mixed signature and ratification and EU-only governance. So with these comments or this different perspective, I hope for more discussion and questions from your side. Thank you very much for your attention.
Excellent, thank you so much for your contribution. I don't know, Guillaume, if you want to reply extremely briefly, but I would even suggest that we go straight to the Q&A because we are in any case slightly over time. So shall we go straight to the Q&A? What do you think?
No, that's perfect. Only maybe on the last point, on the association agreements. I mean, and that the Council still wants to keep this in its realm of mixity. I mean, indeed, from a strict legal point of view, I mean, association agreements as such don't have to be mixed. I mean, it depends on the content and the scope of association agreements. And actually, most association agreements do not include exclusive member state competences. They only include, in most cases, a few examples of shared competences, and then the member states can still decide to have this at the EU level to exercise their competences and have an EU-only agreement, as it happened, for example, in the case of Kosovo, where actually some member states didn't want to ratify an EU-Kosovo mixed agreement because this would mean the recognition de facto from Kosovo. There are some other examples. So indeed, I mean, if there is a political will, a strong political will, association agreements can be included as EU only, or they can be split. But, I mean, it would only be interesting for us to see some developments in that regard. But with this, indeed, I think, Alex, you may open the floor for the virtual floor for questions or comments.
Excellent, perfect. So we have indeed already received some questions. I would encourage our live audience to please send us your questions. We have Robert Finbo, who asks, is there a risk of non-ratification when it comes to more recent negotiations, such as the ones related to CETA and the Mercosur trade agreement, with regard to, again, what we've discussed in terms of the role of member states in this regard. We have also Yana Titievskaya, who instead asks you to elaborate on the provisional application and the condition under which it would end. Her argument is that only for constitutional reasons this could happen, not simply for political developments, let's say. And then also a second question from her, what role for regional parliaments beyond Belgium, also when it comes to regional representatives. And finally, perhaps you could elaborate on the impact of mixity in terms of the perceived external legitimacy of the EU as a trade partner, particularly with regard to external parties attempting to perhaps even circumvent the EU level and let's say negotiating directly at a national level from Carrie Otterburn. Perhaps we can start with this, and then we can have maybe perhaps a very brief second round. You have the floor, Guillaume.
Agree or disagree, or complement maybe also question by question. Is it okay?
Yeah, sorry, we missed the first part, but please go ahead.
Okay, so with regard to the first question and what I mentioned, David, please also come in if you agree or disagree. So with the possibility of non-ratification of CETA and Mercosur, I don't have the number, I don't know it by heart, but I think at this point 13 member states have ratified CETA. Or in any case, if you look at the Council website, you can clearly see which member states have notified already the ratification. It could be that there are more member states that actually have ratified it, but that they still didn't notify the ratification to the EU, because actually this also takes sometimes months before this happens. And I mean, of course, it's very difficult I mean, even not looking at the member states, but at the new parliaments, for example, in relation to Vietnam, I think David has more interesting things to say on that specific issue. But at this point, it's not completely certain, I think, that the European Parliament will give its consent, or in any case, it will not do this easily. And maybe I think most likely there will be some discussions and they will make some noise, and most likely in the end they will give it their consent. But in relation to member states, I mean, in Belgium, even now the Brussels Parliament, and I think also the Parliament of the French-speaking community or from the Walloon region, still have problems with CETA. So it's not a given that now all the member states will suddenly ratify CETA. You never know if for strange political domestic reasons a referendum pops up, like in the case in the Netherlands. So I mean, this is very difficult to predict. So it's definitely not excluded. But in relation to CETA, and this will also be the same for Mercosur, of course, we have the provision application. So whatever happens, 90% of the agreement is in any case provisionally applied. But then, of course, what will happen if one of these member states in the end will not ratify it? This relates to the fourth question, so I will come back on that in a couple of minutes. And only recently also we had the example of Italy suddenly had, for whatever political reasons, problems with CETA, that it didn't protect enough the geographical indications of grappa. Also, again, it's difficult to predict because, of course, in some member states you have very fast changing political scenes. So, I mean, it remains to be seen, but in any case, for CETA and for Mercosur, if they are mixed, in any case, we safe to a certain extent due to the fact of provision application. But what will happen in the case of non-ratification, that was the fourth question. With regard to, I don't know if you want to already comment on that specific question, David, or do you want to give your comments together at the end of the group of questions?
So please go ahead, I'll go after you.
Okay, perfect. Then what happens with provision application? I mean, I don't know, David, if you can put the slides back on, or is it easier that I just continue like this? Alex, sorry.
Of course, yes. If you like, we can definitely do this.
Okay, you can see my slides now, I think.
Indeed.
Okay, so very briefly, the thing that I wanted to mention. On the one hand, national parliaments found it a bit undemocratic when there is provision application, but then there was the question what happens in case of non-ratification. And in this entire discussion in relation to the signature of CETA, both the council made a statement, and they made it very clear that if the ratification of an agreement, or in any case, the ratification of an agreement fails permanently and definitely, when there is, for example, a ruling of a constitutional court, or they are the failure of the completion of the constitutional process. So actually, it's just reverse if, for example, according to constitutional procedures, the member states need to ratify it and doesn't ratify it, the ratification fails, and therefore the provision application needs to be terminated. And it mentions that this needs to be terminated and according to EU procedures. And there was some discussion, or there are some misconceptions in any case about that. For example, there were some states like Germany and Poland, Belgium and Austria saying that member states have the right to terminate the provision application. Even there was the Bundesverfassungsgericht, the German Constitutional Court, which strangely enough said that the German federal government can terminate on its own the provision application, which is of course not the case because this relates to EU competences. So actually you only can have an EU procedure ending the provision application of EU competences. And indeed, in all the agreements which foresee provision application, there are also some provisions saying how to terminate provision application. They just say that both parties, being the EU and or the third country, can terminate the provision application. But what the specific procedure within the EU is, this is rather unclear. This is also not defined in the treaties in Article 218. But most likely you can argue that it is the same procedure to start the provision application. What does this mean? You need a proposal. So if you have a situation that the member does not ratify the agreement, then it's up to the EU to terminate the provision application. So you need a Commission proposal, and then the Council needs to approve this. But of course, the Council decides by qualified majority, or in some cases unanimity. So in any case, you need to have all the member states on board also to terminate the provision application. And there are some examples, but I mean, I will not go too much into detail. And then the third question was the role of regional parliaments. Again, it is only in Belgium where regional parliaments are really required to give their consent. Of course, regional parliaments, and I'm not an expert in the constitutional procedures in federal countries, for example, like in Germany, Austria, but there the regional parliaments or the regions are very strongly engaged in the ratification because they are represented at the level of the chamber. This is not the case in Belgium. There, the regions, directly play a role in the ratification procedure. But again, I mean, I'm definitely not an expert in the federal German constitutional system. And finally, the last question, which related to the legitimacy and if I remember well, the effectiveness and the extent to there's a threat that third countries would directly engage with negotiations. I mean, this is really something different. We have now, for example, this discussion about mixity and non-mixity, but nevertheless, it is clear for everybody within the EU and not always clear for third countries, especially for the Trump administration, that of course the Commission is the sole negotiator. There is the mandate. The Commission negotiates on behalf of the member states, and actually, I don't really see a risk that this would happen. I mean, procedures are very clear. There's really, I mean, they're really very much established. So I don't see really a risk that now suddenly member states would be inclined to do this and that they would then run against infringement procedures. I think the situation is quite clear and the practices are quite well established, and maybe some other countries will try to do this, but I think there is a small risk. And if member states, of course, will be lobbied, but then they will express their position at the level of the Council, and of course it will not happen that suddenly member states will walk away or will not act according to, I mean, the well-established procedures. David, do you want to come in?
Yes, go ahead, David.
Well, I mean, there's really, again, fantastic answers. I just have 2 points to add. The one point being on the threat of non-ratification with regard to the question by Robert. Well, obviously, this is very, very difficult to predict and always depends on, sort of the domestic politics, as Guillaume said, and the basic problem that EU only ratification and signature and ratification tries to overcome is sort of, the instrumentalization or the attempt of member states to weaponize their veto to gain additional advantages in negotiations, or renegotiate certain parts of the agreement. And so there is obviously always the general theoretical threat of non-ratification, but usually it is being employed as a political tool in order to achieve certain objectives, and then there is a political solution. So this is really not a legal method, perhaps, but a political one. So it's like what you see happening in France right now. There's a political situation, a political tension where the president finally submits the CETA to Parliament for ratification, as he knows that he has the votes for a positive result. And but in the end, what we see is that more or less sometimes ratification by member states can take up to 5 years, like in the case of Korea. But it does take that long because sort of the executive waits with the submission of these agreements to Parliament until a point in time when they are certain that Parliament will in fact, or would in fact, ratify such an agreement. So this is a political calculation, and you would expect that the executive would only submit an agreement to Parliament for non-ratification in bad faith, which would, I think, would almost constitute a constitutional crisis or a political crisis at the EU level. The second point on regional parliaments. In Germany, indeed, we have not only the Bundestag, but also the Bundesrat, which is the chamber of obviously of the Länder, of the states, where indeed the states, the Länder, are represented. And here, through that chamber, of course, which also has to ratify mixed agreements, the Länder, the regional parliaments, have their say or are involved. So there is that there's that threat. Again, that's a political calculation, depending on sort of the different balances of Green, SPD, FDP, and CDU involvement in respective in regional parliaments and executives. But that there is that involvement, just to make that statement. I completely agree with Guillaume on provisional application and the role of member states in ending provisional application. The Bundesverfassungsgericht, the German Constitutional Court, has gotten this completely wrong, and this is a matter of this is an EU act, an EU legal act that can only be ended through an EU procedure that is stipulated in 218. So for that matter, a member state would not be able to end a provisional application. And I think Jana's reference was to a political imperative that that member states may have agreed that if one country terminates or wishes to terminate a provisional application, that this would be done in case of CETA, which I think was mentioned in the council minutes that were attached to the signature of CETA at the time. So with that, I leave it at that, and perhaps Guillaume has some additional comments.
Excellent, thank you very much. May I raise an additional 2 questions, and then we bring it to a close? We have Monica Velasco, who asks, what about the EU-Mexico agreement? As there is some speculation, only the trade aspect will be renegotiated, precisely to avoid mixity. And she's wondering whether you have any more background or information about that. And then final I think, interesting question in the context of our webinar today from Yulia Kaspierovich, who asks, ultimately, why do we have mixed agreements? What is the legal and political rationale if member states are ultimately bound to implement such agreements, particularly with regard to the issue of the provisional application? Again, back to you, Guillaume. And if I can ask you both to be quite brief, so that we can finally bring this to us.
Many thanks for the questions, and I'm definitely not an expert in the EU-Mexico FTA, but in any case, so the negotiations are now finalized, and there is now the process of legal scrubbing, where they are trying to really draft the final version of the agreement and to the translation, and only then the Commission will make a proposal, because only what we have at this point about the EU-Mexico FTA is policy documents or statements, but no specific legal acts. I mean, there is even some PR or promotion material that actually is just on the website of DG Trade that I saw this morning, where actually the Commission is already recognizing it will be a mixed agreement because it is part, the trade agreement is part of the broader global agreement, which will then replace the 97 agreement, and therefore, in the light of practice and also in the light of these council conclusions that we discussed before, the agreement will be mixed. And also, I think another, I mean, PR material of the EU, it is already indicated. But of course, the first step will be the Commission proposal for a council decision for the signature of the agreement. So of course, after the legal scrubbing, the agreement needs to be signed, and this can only happen if the Commission first makes a proposal for a council decision, and there it will be the Commission that will have to indicate in the Commission proposal whether or not it will be an EU agreement or a mixed agreement, and then the Council can agree or disagree with the Commission proposal, and then, for example, make it mixed if the Commission did not proposes it mixed. But as it stands now, I think it will, and David mentioned the option of nevertheless still splitting these association agreements, but this could be, I don't know what will happen. But in any case, we will have to wait until the Commission proposal for signature, and I think this will be for this year. I think after the summer, to see really the first, I mean, really legally binding, or in any case, the strict legal instruments where the Commission really takes a decision in that regard. But in any case, my guess is that it will be mixed, and then with on the one hand the mixed agreement, but then with the provision application of a big part of the trade agreement. Then with regard to the offer, I don't know, David, if you want to comment first, or you have comments on the Mexico question.
You go ahead, and then I go after you, if you don't mind.
Oh. Okay, because I couldn't read the second anymore with my on my notes. Can you repeat, please, the second question, Alex?
Why do we have mixed agreements?
Well, basically, yes. To put it briefly, it's legal and political rationale. Yes. Yeah,
I mean, this is what I tried or hoped that it was clear, the legal reasons. With regard to, I mean, the competences, and again, I mean, member states obviously like mixity, but because it gives them this veto right, even in an area of qualified majority voting, and maybe they don't really actually use this during the ratification, but in any case, in the final stages of negotiations, there, in any case, it's already, when it's very clear that an agreement will be mixed, I think member states really can use this, and there are numerous examples of this, to have some to extract some last minute concessions. So that's the main legal reason for that, and then the political reason, and then the legal reasons. This is what we briefly started with, is of course when you have provisions falling on the member state competences included in such an agreement. And then in relation to provision application, I mean, this is just a way then, to go on with the agreement, and to avoid that you have to wait 3-4 years until the agreement can enter into force. And actually, in most cases, member states, on the one hand, prefer mixity, but at the same time, they're also very much fan of this provision application, because in most cases, member states also want to go or continue to implement, I mean, the biggest chunk of the agreement as fast as possible. So I don't know if this really was an answer to the questions, or in any case, I tried. David, I don't know if you have something to add.
Well, perhaps just on the Mexico agreement, you know, given the fact that it's really the trade part that is being updated, and only the trade part that is being updated. I think, you know, referring back to the council conclusions by the Bulgarian presidency, that are conceding, on the one hand, EU-only FTAs to the Commission, if you will, on that side of the institutional battle, and association agreements as mixed agreements to the Council, where they retain a veto right, and member states' parliaments where they retain a veto right. You know, so if you look at this as an institutional power play, the Bulgarian presidency conclusions are, in fact, you know, sort of a reflection of a balance that that the Council and try to strike in response to a demand by the Commission and demand by businesses to say we really need qualified majority voting, and we really need to get rid of member states' parliaments' veto powers, you know, over the course of 5-6 years. These are different times, as I tried to explain, but these are you know, sort of soft arguments here compared to of course, you know, the discussion about competences. But what I mean to say here is that you know, the formulation of the Council conclusions have changed over various drafts. So I've seen previous unofficial drafts of that of these Council conclusions where, you know, this concession of association agreements to the member states was not included, but, you know, it was simply stated that FTAs from now on should be EU-only governance. So, you know, this concession was included later on. However, we have this formulation in there which says dependent on content, and it is, I think, no secret to say here, or just to overt, you know, to be open about that. The Commission very much is of the view that large parts, if not the entire part or the entirety of the new association agreements are or could be ratified as EU only. And therefore, you know, we would see, I think, and this is speculation again, but we would see for every one of these agreements in the future a haggling between the Council and the Commission, or an attempt of the Commission to get EU-only agreements, even in case of association agreements, done for the credibility and effectiveness of the CCP.
If I can add one issue to that, of course, with regard to this entire debate about mixity and association agreements, that this is also a bit paradoxical, because of course association agreements are one of the few examples or cases where actually unanimity is still required in the Council. So actually member states already have veto rights in relation to association agreements at the Council. But I mean, you can have very long legal and technical discussions about the nature of association agreements and whether they should be mixed or not, or if trade agreements are a part of an association agreement, or they are implemented by a decision of a joint institution, which, for example, could be the case in relation to Tunisia and Morocco. I mean, very interesting legal discussions, but the bottom line is, if there is a political will from the member states to make it mixed, it will be mixed. And this will be very difficult for the Commission then to challenge this or even to bring this to court. So, I mean, this will be the result.
Well, thank you both. I'm afraid that's all the time that we have for today. I would really like to thank our excellent speakers, Dr. Guillaume van der Loo and Dr. David Kleimann, as well as our audience members, of course, for taking part in our very first EUCROSS webinar. Before leaving you, I can already announce that Professor Kolja Raube from the University of Leuven will join us on the 25th of July for a second webinar entitled Towards a Stronger Power in the World, Contestation, Legitimacy, Resilience and Recentering in the Age of Anxiety. For further information, please visit our website and follow us on our Twitter account. Thank you for joining us, and we hope you will join us again next time. From Guillaume, David, and myself, thank you and goodbye.
Thank you.